Good afternoon, everybody. Am I audible? Okay. Welcome to the finale of 16th Shankarrao Kanitkar National Moot Court Competition. Now, we would start with the final round with Team B as the petitioner and Team N as the respondent. Team B, you may proceed.
Greetings to the bench. If it may please this honorable court, this is the counsel appearing on behalf of the petitioners in the case of State of Maharashtra versus Union of Hindrashtra. The counsel seeks permission to refer to the bench collectively as your lordship.
Start.
If your lordship is well versed with the facts of the case, may the counsel proceed with the first and the second issue at hand.
Yes.
Much obliged, your lordship, and the co-counsel will deal with issue number 3. Your lordship, the very first issue being that whether the petition under Article 131 of the Constitution of Hindrashtra is maintainable before the Honorable Supreme Court. Your lordship, the Supreme Court has an original jurisdiction over any dispute between the center and the state as enshrined in the Constitution, Article 131 subclause A, as it gives the power to the state that is the right to approach the court whenever constitutional validity is being challenged. Further, even the difference in opinion based on the Constitution or the interpretations difference in the Constitution can also be a sufficient to invoke the jurisdiction under this particular article. Your lordship, the necessary determining factor to invoke this article is that there should be a center state dispute which is very much present here. The state of Maharashtra is being aggrieved due to its violation of rights and powers guided by the Constitution, and for the very same reason, the state of Maharashtra has approached the Honorable Court. Your lordship, secondly, the constitutional power of the state is being violated here. If your lordship could please refer to page number 2, paragraph 8, line 2 of the memorial, which suggests that it is held by the Supreme Court in the state of Rajasthan versus Union of India in 1977 that a dispute should include a point of law or fact on which the existence of a legal right depends on. And the legal right is interpreted to be a sufficient cause of action to invoke this particular jurisdiction. And the mere existence of a legal right, that is the mere existence of a dispute which exists in this present case, invokes the jurisdiction under Article 131 of the Constitution of Hindrashtra, and it is submitted that the petition shall be maintainable. If your lordship is satisfied with the arguments, may the counsel proceed to the second issue at hand.
Yes.
Much obliged, your lordship. The second issue being that whether the central legislature has a legislative competence to enact the 3 farm laws. Your lordship, Article 246 demarcates legislative boundaries present in the 7th schedule, and as per Article 246 subclause 3, it confers legislative powers on the state to enact laws within the subject matters enumerated in the state list or the list 2 and list 3, that is the concurrent list as well. Now, the council would enumerate the exclusive power under list 2, that is the state list. Namely, there are 9 entries, the important ones being entry number 14, that includes agriculture and it's in its domain, all the ancillary and subsidiary matters like education, research, plants, pests, etc. Entry number 26, which talks about trade and commerce. Entry number 28, that talks about markets and fairs. And entry 18, rights.
Are we talking about the list here or the case?
Entry.
Are we talking about the list or the entries in Constitution or the problem?
We are talking about the entries present in the list number 2.
We are not interested in constitutional entries. We are interested in problem beforehand.
Indeed, your lordship. I would proceed with the problem beforehand. First, that
don't go to any entries. Directly go to the problem.
All right, your lordship. So, your lordship, if you could refer to the memorial page 3, paragraph 12, line 1. In the case of Union of India versus Madras Bar Association, it was held that constitutional validity is determined by the lack of legislative competence, which is very much present in this case. Now, your lordship, to argue on the facts, the true nature and character of the enacted farm laws lies within the state list. And it is to be noted that farming is very intricate to the regional needs and regulation of local problems of a state. So if farming is not an occupation and it cannot be brought into the generic ambit of trade and commerce. So if foodstuff, as per entry 33, list 3, is considered tantamount to agricultural produce, then all the state powers in its domain would become redundant, which is contrary to constitutional provisions. Despite Article 246, Your Lordship, it is contended there is no existence of any exceptional circumstances for the center to enact enact within the matters listed in the list 2. Like, for example, there is no exception as per 249. That means the Council of State has not passed any resolution for the same, nor has the state passed any resolution with the presidential assent as per Article 252. There is no proclamation of an emergency, or as per Article 253, there is no adherence to international agreement. As per this.
So you mean to say the state supersedes center in this legislation?
It does, because the substantial matter of the contended laws lies within the state itself. And there is no exceptional circumstances which would guarantee the power to the center to encroach the domain of the state, which is constitutionally provided. Therefore, Your Lordship, the state has its own, it also has to be considered that state has its own climatic zones or its different topography. And thus a uniform central law would proportionally encroach upon the state list, and it would restrict the application of the state list, making the state fail to its regional needs, and it would make it fail to cater to its regional problems, because agriculture is a very state-centered domain. Now, moving on to the second sub-issue, Your Lordship, which talks about the basic structure, that is the doctrine of federalism. Your Lordship, as per stare decisis, federalism is the division of power between the center and the state without sacrificing their independent political integrity. Now, whittling down the state's powers to distort the dual polity system is crossing the boundaries of the federal structure. As per the ruling in a state of Rajasthan versus Union of India, the Indian model of federalism is cooperative in nature, which means that the center and the state should act in harmony to reflect the state's interests. And here the state interests are not being reflected, which shall be, this section would be dealt with the co-council. And they should pool their resources together to reflect the state interest. If Your Lordship could refer to the proposition itself, which states in its first paragraph, line 3, that Hind Rashtra is a federal nation. And as in its line 5, it states that the main occupation of the people of Hind Rashtra is agriculture itself. Thus, the center acts ultra vires to its competency. Your Lordship, the application of constitutional doctrines, that is the doctrine of pith and substance, which ascertains the validity of a law based on the competency, that a legislature would be competent if the subject matter falls in the list that has been provided in the constitution under the 7th schedule to that particular legislature. As agriculture is a true subject of list 2, the center violates doctrine of pith and substance. Moreover, doctrine of colorable legislature states that if something cannot be done directly, it cannot be done indirectly as well. So the transgression of power by the pretense of competency would mean that the center lacks competency indeed. Even if after all of this, if the union legislature contends that they have enacted the formulas within the entry 52 of list 1. Now, Your Lordship, entry 52 of list 1 states that this is power to regulation of industries in public interest, and entry 7 of list 1 states that it deals with industry declaration during war and defense. This is so because entry 52 of list 1 is related to entry 24 and 27 of list 3. And this has also been held in the case of Ishwari Khetan versus Uttar Pradesh, the state of Uttar Pradesh, wherein the Supreme Court has stated that declaration of industries is needed for such industries or for the legislator to enact matters as per the list 1 entry 52. And for all the submitted reasons, since the procedural requirement is not followed, for all the submitted reasons, the council submits that the center lacks competency to enact the 3 farm laws. And now my co-counsel would deal with the issue number 3.
Good.
Much obliged, Your Lordship.
Am I audible and visible?
Yeah.
Greetings to the bench. This is the council on behalf of the respondents dealing with the third and the final issue. The council seeks permission to proceed with the same.
Proceed.
Much obliged. The third issue deals with the constitutionality of the 3 farm laws, and the council will prove its unconstitutionality in a 3-fold manner. That is Article 14, Article 19, and violation of Article 21. Proceeding with the first sub-issue, Your Lordship, is contended that the Article 14 proposes 2 forms of equalities, that is equality before law and equal protection of laws, which entails that equals cannot be treated unequally. So when persons similarly situated are treated differently, such discrimination warrants Article 14. For a classification to be reasonable, there should be intelligible differentia, and the differentia should have a rational nexus with the objective sought to be achieved. So it is contended that the definition of farmers under Section 2E of the Price Assurance Act is a narrow and restrictive definition which lacks reasonable classification and excludes a class of tillers or sharecroppers working alongside from this definition. This classification is unwarranted since their contribution to the farming is no less, if not equal. This excludes a vast share of equal contributors to the farm, and thereby this is arbitrary and lacks merit. The central government has failed to define the class of farmers reasonably, unlike the definition which has been enclosed in the National Policy of Farmers drafted by the National Commission of Farmers in 2007, which is a clear and conclusive definition. Your Lordship, farming is a chain of events with different stakeholders. Farmers by the modern definition, the new definition, do not comprise of agriculture itself. There are classes such as tillers, cultivators, harvesters, each play their essential role in obtaining what we finally get as a farming produce, which is now being sold to the corporates or the APMCs. So all these contributing parties together comprise of the definition of a farmer, and thereby the modern definition or the impugned definition that we have is a very restrictive definition. A quick reference to the National Policy of Farmers definition will tell us why this is arbitrary. Now moving on, Article 14 strikes at arbitrary and unreasonable state action. Every classification that is made by the legislature must be non-arbitrary and reasonable. Otherwise, it is determined by the court of law to declare it invalid. So it is contended that the three farm laws are violative of Article 14 of the Constitution, and the same shall be proven by the Council by citing provisions from the same Act. For example, Section 4.1 of the Price Assurance Act states that the condition for performance of the agreement is based on the standard of farming produce. This clause of standard of farming produce may be profit-oriented and overlooks the environmental impacts that will be needed to maintain these standards, which will in the long run affect the fertility of the soil of the land owned by the farmers and thereby will affect his right to livelihood. Furthermore, Section 13 of the same Act talks about the conciliation board for dispute resolution mechanisms, and it does not define who will be allowed to represent the parties and therefore does not ensure effective representation and assistance. Section 15 and Section 19 of the two acts bars the jurisdiction of civil courts in the resolution of the disputes between farmers and the corporates. So the remedy which is to be sought in this case is provided by the subdivisional magistrate, who is already overburdened, is an administrative body, and whose decisions are not as effective as the decisions rendered by the court of law. This is also a violation of the right to legal aid. Furthermore, Section 13 and 18 provides a safe harbor provision to the same decisions rendered by the subdivisional magistrate, which gives him immunity and thereby is prone to corruption and thereby is prone to misuse. So furthermore, the Essential Commodities Amendment Act has set the price limits too high, which are likely to be triggered very less. So therefore, in case of any price rise, till the limits are not touched, which are 100% and 50%, the poorer and the lower strata will be very much affected. Your Lordship, I will add on to this that Section 7 subclause 2 of the Price Assurance Act enables that the produce purchased by a sponsor under this Price Assurance Act is free from all stocking limits placed under the Essential Commodities Act of 1955. This basically and this essentially provides freedom to legally hoard and inflate sale prices. So for all these above mentioned reasons, it is submitted that the three impugned farm laws are violative of Article 14 of the Constitution of Hind Rashtra. Proceeding to the next sub-issue, Your Lordship, it is contended that the three farm laws are violative of Article 19(1)(g) of the Constitution. Article 19(1)(g) upholds the right to trade and profession, and the same can be restricted only under the reasonable restrictions under Article 19, subsection 2. So Section 2(g) of the Price Assurance Act defines a farming agreement between a sponsor and a farmer. It is contended the clause predetermined quality in this case can be easily misused by the sponsor in order to renegotiate the contract to a lower price or completely refuse to honor the contract. This is because the farming produce which we obtain might not always match with the predetermined quality as agreed upon before the sowing season between the farmers and the corporates due to various ecological and geological factors which come into play, such as bad rainfall or such as attack of pests or bad weather, which are beyond the control of the farmers, and this leaves the farmers in a precarious position. If you observe that the acts do not put any safeguards to which prohibits the corporates from refusing to honor the contract entirely. So it is submitted that the impugned laws are violative of Article 19(1)(g) of the Constitution. Proceeding to the final sub-issue, Your Lordship, it is contended that the three farm laws uphold Article 21 of the Constitution, and it violates Article 21 of the Constitution, and the same shall be proven in a twofold manner. Firstly, it's the violation of right to livelihood and non-compliance with procedure established by law. Your Lordship, the right to life and liberty has a wide connotation under it, and an important facet of this important right is that the right to livelihood with proper means of living and not mere animal existence. The same was cited in the Olga Tellis case. So it is contended that the minimum support price should be guaranteed to a farmer to protect their right to fair livelihood. MS, the issue of minimum support price is inextricably linked with the farmer's right to earn a fair share of livelihood. It is submitted that the replacement of respective state farming policies with an unified central law without the provision of MSP violates the farmer's right to seek fair and minimum wages. Furthermore, the directive principles of state policy under Part 4 of the Constitution sets out objectives that a state needs to undertake in order to achieve the goal of a welfare state. Harmony and balance between fundamental rights and directive principles is a part of the basic structure of the Constitution. Articles 38 and 39C directs the state to minimize income inequalities, and Article 43 directs the state to secure the living wage for their farmers. It is contended that due to the differing economic strength of both the parties, of the farmers and the sponsors, it will lead to unequal bargaining power. This unequal bargaining power provides them with a dominant position, and they can abuse this dominant position on the weaker party, that is the farmer, which will inevitably lead to lesser or unfair remuneration. So this will affect the minimum wage of the farmers by jeopardizing their livelihood, and this also is antithetical to the goal of establishing a welfare state, Your Lordship. Moving on, the apex court in Maneka Gandhi versus Union of India laid down important principles regarding determining the validity of the procedure which deprives a person of his right to life and liberty. The triple test that should be followed in this case is that there should be prescription of procedure for depriving the right. It must satisfy the test of the relevant fundamental right under Article 19, and it must satisfy the test of Article 14. So it is contended that sections, as I mentioned earlier, sections 13 and 18 of the two acts provide a safe harbor provision which provides immunity to the decisions of the judicial officer, which is the subdivision magistrate. So in this case, there's judicial review. He's immune from judicial review, which gives him and which makes him immune from scrutiny, and thereby this is a violation of the procedure established by law. Furthermore, the arbitrary exclusion of classes and this narrow and restrictive definition propounded by the center excludes a lot of classes equal contributing contributing classes to the farm, and therefore this is also violative of Article 21. Furthermore, as established earlier, the impugned laws are also violative of the tests of Article 14 and 19, and therefore should be declared unconstitutional. So therefore, it is finally submitted that the impugned legislations violate the Golden Triangle articles of the Constitution, which are Articles 14, 19, and 21, and therefore should be declared unconstitutional. So if your Lordship is satisfied with the arguments advanced, the Council would like to move to the prayer.
Proceed.
Much obliged, Your Lordship. So wherefore it is humbly prayed before this Honorable Court that in light of the issues raised, arguments advanced, and authorities cited, the Honorable Court may be pleased to hold that the petition under Article 131A is maintainable, declare that the Central Legislature lacks the competency to enact the three farm laws, and declare that the impugned farm laws are unconstitutional on the grounds of violation of Articles 14, 19, and 21, and also violates the basic structure of the Constitution, and/or ask any direction, order, or relief if it may deem fit in order to uphold the principles of justice, equity, and good conscience. And for this act of kindness, the petitioner shall forever humbly pray.
Thank you.
Counsel for the respondents seeks permission to address the bench.
Yeah.
Continue.
With due permission of the bench, the council would like to address the judges singularly as your lordship and collectively as the lordships.
Proceed.
Do not
Wait,
waste
please.
time. Hello. Do not waste time in procedures. Directly come to the
Arguments.
The contentions are divided as follows. The first contention is presumption of constitutionality in the favor of three farm acts. Second, the authority of the parliament to pass the three farm laws. Third, the parliament has not breached the spirit of federalism as envisaged by the constitution. And fourth, the free farm laws are in consonance with public policy and have adequate safeguards to protect the interests of the farmers. Issues 1 and 2 will be dealt with by me, and my co-counsel will deal with issues 3 and 4. I'll be taking 13 minutes for my arguments. My co-counsel will also be taking 13 minutes for his arguments. We would like to reserve 4 minutes for rebuttals and answering the questions of the bench. The counsel humbly seeks permission to proceed with the first contention.
I've already told you, don't waste time in procedures.
Honestly, Lordship. Highly obliged, Your Lordship, proceeding with the first contention, it is submitted before this honorable court that there is a presumption of constitutionality in the favor of the three farm laws in favor of the respondents. It is a well-settled principle that there is always a presumption in favor of constitutional validity of any legislation unless the same is set aside for the breach of provisions of the Constitution, as established in the ML Kamra versus New India Assurance case. It is for the petitioner who challenges the validity of the law to establish that it is not constitutionally valid. The presumption is not absolute, however, and does not stand when there is a gross violation of the Constitution, as mentioned in the case of K. Anjanaya versus K. Chandra. In the present petition, however, there is absolutely no violation of the Constitution, specifically in terms of the legislative powers of the center, as conferred in the 7th schedule of the Constitution. Hence, the presumption of constitutionality persists in the said case, and the burden of proof lies with the petitioners. Proceeding with the next contention, it is humbly submitted that the Parliament has authority to pass the 3 Farm Acts under entries of the concurrent list of the 7th schedule of the Constitution of India. This contention is divided into 3 sub-contentions, each dealing with one of the farm laws and proving its legislative competence. Proceeding with the first sub-contention, it is humbly submitted that the purpose of the Farmers Produce Trade Commerce Promotion Facilitation Act 2020, hereinafter referred to as the Promotion Facilitation Act, is to provide more freedom to the farmers and traders with respect to sale and purchase of farmers' produce. It promotes barrier-free interstate and intrastate trade and allows farmers to trade outside the APMC and other notified state markets without any extra cess. It also provides a facilitative framework for electronic trading of the same. The same definitions and of the said act can be found in the preamble of the said act and is also in para 4 of the written submission. The subjects on which the Promotion Facilitation Act rules upon can be captured in the phrase farmers produce. The phrase is defined under the act to constitute of foodstuffs, cattle fodder, including oil cakes and other concentrates, raw cotton, both ginned and unginned, cotton seeds, and raw chuk. This definition can be accessed in the section 2 of the said act. The aforementioned definition of the farmers' produce is covered under subjects mentioned in entry 33 of list 3, that is the concurrent list of the 7th schedule of the Constitution of India. Hence, it is humbly submitted that as the said subjects are featured in the concurrent list, the Parliament is empowered to make laws regarding the same as per Article 246 of the Constitution of India. Proceeding to the next act, it is humbly submitted that the purpose of the Essential Commodities Act, that is hereinafter referred to as the ECA Act, is to amend the Essential Commodities Act 1955. The act amends the that act mandates that agricultural foodstuffs can only be regulated by the central government only under extraordinary circumstances. It also mandates that the imposition of a stock limit on the same would also be based on price rise, subject to conditions and exemptions. This reference to the same can be found in the amending section 1A of the act and is also mentioned in para 14 of the written submission. It is submitted that the definition of the word agricultural foodstuff as mentioned in the ECA Act is the same as the definition of farmers' produce as mentioned in the Promotion Facilitation Act. Hence, following the same pattern in the Promotion Facilitation Act, the definition also falls under entry 33 of the concurrent list. The Parliament hence has the power to pass the ECA Act as well and the legislative competences. Lastly, coming to the Farmers Empowerment and Protection Agreement on Price Assurance Farm Services Act 2020, hereinafter referred to as the Empowerment and Protection Act, it is submitted that the purpose of the Empowerment and Protection Act is to provide a comprehensive, fair, transparent, and national framework on contract farming between corporate firms, processors, etc., and the farmers. Contract farming, as per the Act, is in relation to sale, purchase, trade of farm services, and farming produce. The same can be found in the preamble of the said Act and the para 7 of the written submission. The subjects on yes, Your Lordship.
How do you uphold the constitutional validity of this?
Of Your Lordship, the which act?
All the 3 acts.
Your Lordship, there is a presumption of constitutionality in the favor of the 3 acts as established by me in the first content.
It is not established, it is just contended.
Yes, Your Lordship. It is
established.
Yes, Your Lordship. So, Your Lordship, the petitioners in this present case have to establish that the 3 laws are unconstitutional. If they fail to establish,
you have not established anything yet. Establish it. Don't contend.
Your Lordship, for any act to be constitutional, it has to have the legislative competence and it has to not violate any of the fundamental features or any of the fundamental rights of the Constitution. as envisaged by the Constitution. In the present case, all the three laws have been passed under entry 33 of the concurrent list. Hence, the legislative competence lies with the Parliament. And further, the three acts do not encroach upon any of the fundamental rights or any other fundamental features, including that of feature of federalism. Hence, these are constitutional in nature. If that satisfies your lordship.
Continue.
The subjects on which the Empowerment and Protection Act rules upon can be conferred in the phrases contract, farm services, and farming produce. The definition of the phrase farming produce given in this act once again matches the definition of farmers produce of the Promotion Facilitation Act and that of agricultural produce in the ECA Act. As a result, this part of the act also falls under the ambit of entry 33 of the 7th schedule of the Constitution of India. Further, it is submitted the phrase contract covered in entry 7 of the concurrent list is also covered under entry 7 of the concurrent list. Hence, the Parliament is empowered to pass this part of the act as well. Lastly, the definition of farm services as per the same act is supply of seed, feed, fodder, agrochemicals, machinery, technology, advice, non-chemical, agro inputs, and other inputs for farming, which can be found in section 2 of the same act. The subjects, namely seed, feed, fodder, are mentioned in entry 33 of the concurrent list. Furthermore, subjects such as agrochemicals, machinery, technology, agro inputs, and other inputs for farming fall under Schedule 1 of the Industries Development and Regulation Act 1951. And as per entry 33 subclause A of the concurrent list, the Parliament is empowered to make rules regarding trade, commerce, production, supply, and distribution of controlled industries as under Schedule 1 of the said Act. This is also affirmed in this case of State of UP and another versus Mesa Synthetics and Chemicals 1991, where the judges said and the council courts, both Parliament and states have the power to legislate in respect. Your Lordship?
Citation. Where is it cited?
Your Lordship, it is cited in the memo, and the citation for the said case is 4 SCC 139.
4 SCC
139.
Year.
Yes, you'll pardon your Lordship.
Year.
Year, sir, 1991. Your Lordship, shall the council proceed with the arguments?
Yes, true.
So, as per the MS Synthetics and Chemicals 1991, where the judges said that the council courts, both Parliament and states have the power to legislate in respect of trade and commerce in production and supply and distribution of products of a controlled industry. As all three parts of this act are covered under entry 7 and 33 of the concurrent list, the Parliament is legislative competent to pass this act as well. That is the end of the second contention, your Lordship. And with that, I would like to ask if any questions are necessary in this particular contention, your Lordship.
No.
I would now like my co-counsel to proceed with the remaining contention. It was a pleasure arguing before this court.
Counsel seeks permission to address the bench.
Yes.
Much obliged, your lordships. May it please this honorable court, this is the second counsel appearing for the respondents in the present case, and the counsel would argue this using two contentions, first of which deals with the fact that the Parliament has not breached the spirit of federalism, and secondly, that the laws are in accordance to public policy and welfare of the people. It is humbly submitted that the Parliament has not encroached upon powers of the state legislatures under the state list of the 7th schedule of the Constitution of India. To prove this point, it is further submitted that the doctrine of pith and substance should be applied to all three acts, that is, the Promotion and Facilitation Act, the Empowerment and Protection Act, and the Essential Commodities Amendment Act. Before proceeding into the sub-contentions, it is humbly submitted that entry 14 of the state list does not apply to any of the acts so passed. The reason for this being that the term agriculture, as mentioned in this entry, only refers to the science or art of cultivating soil, harvesting crops, and raising livestock. Similar definitions of agriculture have been given in the judicial dictums of CIT versus Raja Binoy Kumar Sahas Roy, relying on various authoritative legal dictionaries. Your Lordship, it was observed by Lord Coleridge and R.V. Peters, and I quote, "I'm quite aware that dictionaries are not to be taken as authoritative exponents of the meanings of words used in Acts of Parliament, but it is a well-known rule of courts of law that words should be taken to be used in their ordinary sense." The point to be noted here, Your Lordship, is that none of the definitions given for the term agriculture relate to the distribution, trade, and commerce of agricultural produce. Hence, when applying the pith and substance test in the following submissions, entry 14 of the state list shall not be referred to. Lordship, it is humbly submitted as provided earlier in paragraph 3 and provided paragraph 4 of the written submissions. The Promotion and Facilitation Act falls under entry 33 of the concurrent list. Further, due to the wording of premises of markets or deemed markets notified under various states in the Act, it also impinges slightly upon entry 28 of the state list, which grants the power to make laws regarding markets and fairs to state legislatures. However, Your Lordship, it must be noted that impingement upon the state list is marginal and the majority of the Act is covered under concurrent list only. This is because the Act does not per se legislate on the markets of the states. Rather, it only allows the farmer to sell their produce outside the markets. Hence, the Act passes the established principle of pith and substance and is legally competent and constitutional. Your Lordships, further, it is humbly submitted as earlier established by my co-counsel and provided in paragraph 7, 8, 9, 10, and 11 of the written submissions. The Empowerment and Protection Act falls under entry 33 and entry 7 of the concurrent list. Entry 7, which deals with contracts including partnerships, agency, contracts of carriage, and other special forms of contracts, but not including contracts relating to agricultural land. Lordship, under section 15 of chapter 3 of the Empowerment and Protection Act, the term agricultural land is mentioned. And as per entry 18 of the state list, the ownership and transfer of agricultural land falls under the purview of the state legislature. However, on a close reading of section 15 of chapter 3, it is found that the Act does not legislate upon anything related to the agricultural land. It only safeguards the right of a farmer over his land, even during recovery of any due pertaining to the contract. Further, Your Lordship, Section 8 of the Empowerment and Protection Act specifically mentions that the farming agreements cannot be entered for the purpose of any modification, transfer, including sale, lease, and mortgage of land or premises of the farmer. Hence, the term agricultural land has been used in a negative sense in the Act and actually prevents the law from encroaching upon the state list. Hence, as the Act does not even touch the state list, therefore this Act automatically passes the pith and substance test by the virtue of entry 33 of the concurrent list from which it derives its powers. Lordship, it is humbly submitted in paragraph 13 of the written submissions. The Essential Commodities Amendment Act falls under entry 33 of the concurrent list. And it is further submitted that no entry of the state list covers anything mentioned under the said Act. Hence, the Act also passes the pith and substance test without any contest. Your Lordship, now the Council would plead on the fourth contention, which deals with the fact that the farm laws are in consonance with public policy and for the welfare of the farmers. Much obliged, Your Lordship. Your Lordship, the respondent respectfully submits that the Honorable Court that the three laws, that is the Promotion and Facilitation Act, the Empowerment and Protection Act, and the Essential Commodities Amendment Act are for the benefit of the farmers in consonance with the public policy and are equipped with inherent safeguards to protect them against any exploitation from powerful organizations and corporates. It is further submitted that by eliminating the APMC monopoly, the Promotion and Facilitation Act does away with the long-standing challenge of middlemen. The said Act would also lead to an open market, enabling improved price discovery, supply chain efficiencies, and dynamic market linkages. Your Lordship, these investments will strengthen infrastructure, improve tools, and modernize the sector. The open market structure would also allow the farmers to sell their produce online.
What do you say about MSP?
Certainly, Your Lordship. Lordship, MSP is still going to be declared by the center, and the three acts do not encroach upon anything related to the MSP. And the MSP was applied in the jurisdiction of the APMC markets, which are regulated by the states. And it is still going to be done. And the three acts, again, do not encroach upon any powers of the state relating to the MSP or the APMC jurisdictions.
Also, your take on demand for MSP is agreed upon.
Your Lordship, MSP isn't a legal right, and this petition isn't challenged on the basis of MSP. It is challenged on the basis of federalism. And MSP not being a legal right, it is declared by the center before each year, and it again applies to the APMC jurisdictions. And the demand is for the APMC to be a legal right, which is subject to a different petition and is not a part of this case because it is a case filed by the state about encroachment of their powers. If your lordships are satisfied.
If you have gone through the problem, it specifically mentions the farmers demanded AMC.
Certainly, your lordship. The farmers do demand the MSP. However, this petition is filed by the state about encroachment of their powers with the principle of federalism and the encroachment on their powers on the entry 14 of the state list.
Good.
Much obliged, Your Lordship. Also, the liberalization of the market will introduce corporate and private investments in the industry. And the act allows the farmers to have freedom of choice, which leads to greater competitiveness and better prices, which subsequently leads to a greater standard of living for the farmers as their incomes get boosted by this act. This is in consonance with Article 47 DPSP of the Constitution of India, which states to raise the level of nutrition and the standard of living of people and to improve public health. Further, there are inherent safeguard mechanisms in the Act so as to protect the farmers. This point can be elucidated by the fact that Section 8, 9, and 10 of the Act provides a robust and efficient mechanism to resolve disputes, and Section 4, Subclause 3 mandates speedy payment to the farmer. Also, it is humbly submitted that the Protection and Empowerment Act provides a national framework on farming agreements that protects and empowers farmers to engage with agribusiness firms, processors, wholesalers, etc. for farm services and sale of future farming produce at a mutually agreed remunerative price framework in a fair and transparent manner. That allows farmers to engage in predetermined contracts to guarantee good and competitive prices. It shifts the factor of uncertainty from the farmers to the traders or companies, and it allows farmers to trade freely without the need for a stock restriction, so that increased competition among farmers results in a higher pricing for farmers. Your Lordship, similar to the Promotion and Facilitation Act, this act is also in consonance with Article 47 and promotes the standard of living of farmers by increasing their income. Further, Section 15 mandates that no action of recovery can be initiated against a farmer's agricultural land, and there are inherent safeguard mechanisms in the Act so as to protect the farmers. This point again can be elucidated by the fact that Sections 13 and 14 of the Act provide a robust and efficient mechanism to resolve disputes. Further, the Essential Commodities Amendment Act mandates that the center can now only regulate foodstuffs, which is subject to entry 33 of the concurrent list, and a few other commodities only during extraordinary circumstances. This provides greater confidence to value chain supply and cold chain supply companies and to set up in the country and promote business. The Act also regulated the stock limits and makes the system more conducive for business. This will lead to better prices and more business opportunities for farmers as well, for the industry to grow, for a better future for themselves. Hence, this act also indirectly opposes Article 47 of the Constitution of India. Your Lordship, that is the end of my arguments. If your Lordship permits, the Council would now like to proceed with our prayers.
Go ahead.
Much obliged, your Lordships. Wherefore, in the light of issues raised, arguments advanced, and authorities cited, this honorable court may graciously be pleased to declare that, firstly, the Parliament had the legislative competence to pass the 3 farm bills. Secondly, the 3 farm laws are constitutional and do not violate the principle of federalism and the basic structure of the Constitution. And thirdly, the petition of the state of Maharaja shall be dismissed, or pass any other order or relief in favor of the respondent in the larger interest of justice, with all of which is respectfully submitted. It was a pleasure arguing before this court.
Thank you.
Your Lordship, may the Council on behalf of the petitioners go for the rebuttal round?
Just explain to me, how does it affect the federalism? How do the 3 laws affect the federalism concept of the country?
Lordship, this question posed to which council?
I think it is the lady in front of me.
All right, Your Lordship.
Much obliged, Your Lordship, for the question. Your Lordship, federalism is a doctrine which divides the powers between the center and the state, and they have been substantially done to include the matters which are intricate to each and every detail. Now, Your Lordship, the agriculture is within the state's domain because agriculture is dependent on various factors and the topography of every state is different.
No, the question. Did you understand the question?
Yes, Your Lordship, the question is about how does it affect federalism?
Yeah.
The council intends to explain the same, that because this is the reason why the powers have been divided, and when the center tries to encroach upon these powers or make the list in a very interprets the list in a very generic manner to include the subjects in the state list, this is how it affects the power of federalism, because then the state's power in its domain would become redundant. And as federalism is a basic structure doctrine, it is not being followed in this very particular matter.
Just hold on. There's some technical glitch.
ऍग्रिकल्चर कसा देतात?
स्टेट लिस्ट मध्ये येते ते. ऍग्रीकल्चर कॉन्सेंट्रिक स्टेट लिस्ट एकदा कन्फ्युजन.
तुम्हाला म्हणून सिनियर टीचरला बोलवा. Continue.
Yeah, you continue, please.
Lordship, may I continue with the answer
Yeah,
again?
sure.
Continue.
Your Lordship, if you could refer to the memorial in which on page 4 it states that the federalism is a concept that unites and separates states into a union without sacrificing their fundamental political integrity. Your Lordship, as stated by the council before, as these state subjects, as these matters of the impugned laws here are directly related to agriculture. Now, they cannot be brought under the broad ambit of trade and commerce, because trade and commerce would include all kinds of trade and commerce relating to the primary, the secondary, or even the tertiary sector. So the substantial matter should be looked upon, and this is why the basic structure doctrine, that is the doctrine of federalism, has been violated here. Your Lordship, it is very clearly mentioned in the proposition itself that Hind Rashtra is a federal nation, and when the constitution inherently divides the powers between the center and the state for its respective domains, that should be adhered to. Also, to substantiate the same, that why federalism has not been, why the rule of federalism has been violated is because agriculture is very intricate to the state subject, because it depends on a lot of different various factors like topography, the climate, and the land structure of every state, which is intricate to the same. And bringing in a unified law would just make the state's power redundant in its domain provided by the constitution itself. The center cannot hide under the ambit that it comes under trade and commerce, but there are, as the opposing counsel, learned counsel, has very rightly stated, that foodstuffs comes under the concurrent list. Yes, it does, but it contains only few subjects like food, cattle fodder, raw jute, raw cotton, they do not even cover the main agricultural crops or main agricultural ingredients. It is just a sub-clause of the wide ambit of trade and commerce. And that is why, as the substance of these laws do not lie in the central list or the concurrent list, it is a violation of the structure of federalism.
Okay.
Your Lordship, may I proceed with the rebuttal round?
Yes.
Your Lordship, the same question that has been posed to the council is being posed to the opposing learned council, that they have established, they have contended that there are extraordinary circumstances in which they, that is the center, have enacted these farm laws. The extraordinary circumstances have not been established in this particular case. And the same contention that the council has used before, that these lists, the list number 3, entry number 33, covers foodstuff, but it covers it's under the ambit of trade and commerce, which is an extremely wide, giving discretionary power to the center, and this wide ambit would make the state powers lose its constitutional essence. And for the same reason, the substance of these laws should be considered. And this is the question that is posed to the opposing counsel, and my co-counsel would also have some questions for rebuttal.
Okay.
If this council may please proceed.
Proceed.
So, as learned opposition counsel contended that this policy is in public welfare, the council would like to ask them that why is the decision of these the divisional magistrate or the public officer been given immunity from judicial review? Because then it becomes prone to corruption, and that again goes antithetical to the very vision
Excuse
of
me.
welfare. Indeed, Your Lordship.
Don't ask the other parties. We are not here for any debate.
Indeed, Your
Continue.
Indeed, Your Lordship. Moving on, the next rebuttal is also built on the same premise that if the policy is in public welfare, then why has no safeguards been given? Which prevents or which punishes the sponsor from withdrawing to honor the contract. These two are my rebuttals. If the petitioners could respondents could kindly please reply.
The counsel for the respondents seeks permission for the rebuttals.
Yes.
Your Lordship, firstly, it has been argued by my learned opposing counsel that all of these, the main crux of the argument falls under entry 14 of the state list that includes agriculture. However, as stated by my co-counsel, the definition of agriculture never included the trade, products, producer, commerce, or supply of anything. These three acts are not actually dealing with agriculture in any form or any way. They're only dealing with the trade and supply of the farmer's produce. That has been the main contention. And Your Lordship, because of this particular case, the Python substance that they have also invoked does not apply. Article entry 14 cannot be applied. And also, for some reason, the opposing counsel contended that the respondent had contended that these farm laws were passed under extraordinary circumstances. That is not the case, Your Lordship. We haven't contended anything as of such. Apart from this, entry 26 and 27 were also contended by my learned opposing counsel. However, they should know that these entry 26 and 27 of the entry state list are actually subject to entry 33 of the concurrent list, and these laws are actually passed under entry 33 of the concurrent list. Also, my opposing learned counsel contended that if the foodstuffs were to be given such a wide definition, they would encroach upon the definition given in agriculture. Well, that is not the case, Your Lordship. Agricultural produce would also include many other items which are not under the ambit of foodstuffs. These would, Your Lordship, could I request for an extension
No.
of half a minute?
No.
Yes, Your Lordship, the counsel would like to rest the case with that.
Hereby we declare that the final round is over and the results will be declared within 10 minutes.
Will the results be declared in the same room?
Yeah, kindly wait in the same room itself.
All right, thank you.
Very good evening to all the participants and the teams who have participated in the final round. We are at the closing ceremony of this it was 16th Shankarrao National Moot Court Competition, and I would now request Dr. Chintamani Ghate sir, coordinator of Model Law College, to announce the results because our participants are eagerly waiting for the same. Sir, over to you.
Best Speaker Award goes to H.N. Sri Harini, Dr. Ambedkar Law University, Chennai. Once I announce the runner-up, winners will be automatically. Runner-up team is Symbiosis Law School, Pune. Winner team is Rajiv Gandhi National University of Law, Punjab. I congratulate all the winners and
wish you all the best, and we'll be sending you the trophies also. And about the vouchers, we'll just do it NFT right now after the competition.
Okay, thank you guys.
Thank you.
Thank you so much.
Thank you.
Thank you.
Thank you so much.
Thank you so much.
Congratulations to the team.
Thank you. Congratulations to the runner-up team as well.
Thanks a lot.
A very good afternoon to all of you. We have finally announced the results. I would like to congratulate once again to the winning teams, and also if you are runner-up, definitely that doesn't mean even an inch lesser, because even that is a big effort. And congratulations to the winning teams as well as the runner-up team as well as the best speaker. I would like to propose the vote of thanks for this event and officially mark the end of today. I would like to thank Honorable Chairman Dr. Gajanan Ekbute sir and the members of Progressive Education Society for giving us this opportunity for hosting the competition. I thank Advocate Dr. Chintamani Ghate sir, Coordinator Modern Law College, and Dr. Sunita Adao ma'am, Principal Modern Law College, for believing and trusting us with the responsibility for this competition. I thank all the judges of all the respective rounds for giving their precious time and judging this competition and evaluating it. None other than all the participants. I would like to thank all the participants for being a part of this competition, and congratulations to them for being a part of this. Last but not the least, teaching, non-teaching staff of Modern Law College, all the student volunteers who have been a big part of this process right from the start of the competition. I would like to thank all of them, and I would like to officially declare the end of 16th Shankarrao Kanitkar National Moot Court online Moot Court competition. Thanks a lot for your time and take care.